Good morning, good afternoon, everyone, depending on where you are joining us from today. I'm Amrita Toure, Associate Director of Strategic Partnerships and Engagement for British American Business, and I'm delighted to welcome you on behalf of BAB to today's session. For those of you who may be less familiar with BAB, we are the leading transatlantic business association supporting companies operating in both the US and UK markets. Through our 120 events and programs a year, we aim to provide our members with timely insights into the issues shaping transatlantic trade and investment. Right now, organizations are continuing to navigate the impact of developments that have reshaped the US immigration system over the past year. And so we are very fortunate to have a distinguished panel of specialists today who will explore what these developments mean in practice for employers. I have no doubt this will be a very insightful discussion and will, of course, leave some time after to answer your questions. If you would like to ask a question after the initial presentation, please feel free to submit via the chat and direct it to Stephen Maltby. On behalf of BAB, I would like to sincerely thank Gibney for their generous support of this session today. And with that said, I'm very pleased to introduce Stephen Maltby, board member of BAB and a wonderful supporter of ours. Stephen is a partner with the Immigration Practice Group at Gibney and will be moderating today's session. Stephen, over to you.
Well, thank you very much indeed, Amrita, and to all of your colleagues at BAB for hosting this event. And good morning and yes, good afternoon to everyone. And thank you all so much indeed for joining us today for an update on US immigration a year later and what's to come. It was, I think, just under a year ago that we gave to BAB members our assessment of what was to come with the new administration and the policies that we expected to see being implemented. After all, everyone had had a glimpse of those policies during the first Trump administration from 2017 to 2021. But I don't think that anyone really expected the extent to which new immigration policies on hiring foreign nationals would be implemented and the speed of enactment. Every day, we've all been witnessing a very changed immigration landscape, and those of us who are involved in mobility have been significantly impacted by the America First agenda that prioritizes domestic hiring and increased scrutiny on the hiring of foreign workers. These policies have significantly reshaped global immigration, and as we will see, key impacts have been stricter H-1B visa regulations, a new experience for students who are contemplating to come to the United States and students who are already here, increased enforcement with enhanced vetting and worksite visits, new options for the wealthy, higher fees, adjudication pauses, travel bans, and increased administrative backlogs, to name a few, all of which are forcing organizations to rethink their talent acquisition and relocation strategies. In this program, then, we're going to break all this down by addressing them in three core topics. First, what is the impact of these policies on pipeline talent? Secondly, what are the primary areas of compliance that employers and indeed employees need to be watching out for? And then finally, what is the impact on mobility? There is, with all of this, so much to unpack, but I'm delighted to introduce my colleagues at Gibney, Aisling Ryan, Violetta Petrova, and Beulah Illingworth, who are going to peel back these very large onions. So without further ado, let's start in on the impact on talent pipelines for temporary work authorization, and in particular, take a look at what has been happening to the H-1B, F, TN, L, and other visa categories. And Beulah, maybe I could start with you. Perhaps the most dramatic of these developments has been on the H-1B visa And it is, of course, the H-1B visa that has really been the workhorse of non-immigrant visas for hiring foreign talent. What's been happening there?
Yes, thank you, Stephen. As you mentioned, the H-1B program is one of the largest areas where we've seen some real seismic changes. I will speak about two main updates to the H-1B program that have majorly impacted employers and individuals over the past year. The first is the H-1B proclamation, and the second is the upcoming H-1B cap lottery program for this year. So turning to the proclamation first, as you may all recall, in the late evening of September 19 of 2025, the president issued a proclamation which was communicated by the administration as a first step towards significant change for the H-1B program. So, with a 48-hour warning before coming into effect, the proclamation announced that there would be a $100,000 fee required to be paid for any individuals seeking to enter or re-enter the US in H-1B status. So, as you can imagine, this sent a huge panic and had quite the ripple effect throughout the immigration community, with hundreds of individuals sort of rushing to get back from travels into the United States before the impending deadline came down. One of the main areas of concern at the time that this was going on was the lack of clarity around the proclamation, specifically whom it applied to and how it was going to be applied. There were a set of FAQs published at the time that the proclamation went into place, but unfortunately, they served to provide further confusion and muddy the waters rather than bring the clarity that individuals needed at that time. Finally, on October the 21st, the administration did issue more official guidance, which clearly stated that the fee applied to petitions where the beneficiary was outside of the US, but it did not apply to individuals who were beneficiaries of an H-1B petition that were outside of the US that had an approved petition before the proclamation went into effect. But again, of course, as you can imagine, a very anxious and worrying time for the immigration community. Along with the travel constraints that the proclamation brought, one of the other main side effects that we've seen and that's been immediately felt is the impact that it's had on legal filing strategies and flexibilities around H-1B filings. So whereas before employers could plan more liberally to bring in talent and avail of things like consular processing and other flexibilities, employers are now required to file H-1B petitions from within the US to avoid being subject to that $100,000 fee. And those petitions must be filed either as an H-1B extension or as a change of status request. So employers need to ensure that the beneficiaries are in the US at the time that the H-1B is filed, and they also need to ensure that they remain in the US and don't leave until the petition's been fully adjudicated. So the flexibility of consular processing for H-1Bs has essentially sort of been removed since the proclamation went into place, as this type of filing would, in all likelihood, invoke and trigger that $100,000 fee. So overall, the proclamation's quite significantly altered the landscape for H-1Bs in many ways. It's brought heightened challenges for travel, flexibilities, resource planning, and general global mobility for workforce. There is ongoing there's ongoing litigation at present for the challenges against the proclamation. There's 3 pending lawsuits, the major one being brought by the Chamber of Commerce, and that's currently at the appeal level with the US Court of Appeals. We are due to hear back a decision on that anytime soon, could be within the immediate weeks. But regardless of how the lawsuits shake out, the proclamation is due to sunset a year after it went into place. So September 21st of 2026, the proclamation will sunset unless the administration directly chooses to extend it, of course.
Wow, well, thanks very much, Beulah, for that. You know, we're all on the edge of our seats to see what the Court of Appeals does. And then, of course, it'll probably go up to the Supreme Court and it'll be the traditional journey. But thank you for that great summary. Let me ask you, when you sort of reflect on all of the, if you like, the chaos that the proclamation initially caused, and then things, yes, started to settle down with USCIS guidance. Do you think that the proclamation has ultimately achieved its America First goals of protecting American workers and encouraging domestic hiring?
Yes, absolutely. As you mentioned, we're operating in an America First policy-driven era. And I do think the proclamations definitely had somewhat of a chilling effect on the H-1B program overall. Another impacted area of the program where we could continue to see that chilling effect is with the upcoming H-1B cap lottery and the newly implemented changes there. So to pivot to speak about that, this year we're being met with a new wage-based lottery system for the H-1B cap program. So whereas in previous years the H-1B cap has been a real lottery selected at random, this year, while it is still a lottery, not everybody has equal odds. So you can think about it more as a raffle than a lottery, and whether a registrant enters that raffle with 1, 2, 3, or 4 tickets depends on how high the registrant's salary is. So what does this mean for employers from a practical sense? Well, first of all, the burden on information gathering and legal analysis has now been moved to the forefront of the program rather than at the actual time of filing the H-1B petition. So the determination of which level an individual will be entered into for the lottery requires a legal analysis on the salary, the area of employment, and the job classification for the offered position. So essentially, employers are required to provide this information now in March 2026 for individuals that they plan to sponsor in October 2026. So this is requiring a lot more forethought and planning from an employer perspective with regards to decisions on compensation, consideration for annual bonuses, promotions, job allocations, and general resource planning throughout the year. There's also the question of consistency being raised. So the information that employers are providing now needs to be ripe through October, and there's been little guidance from the administration on how they plan to handle or address any inevitable changes or fluctuations in people's roles over that 7-month period of time until sponsorship would kick in later into Q4 of this year. For the individual level and changes that we can anticipate may be felt. Students coming out of graduate programs and entering into first-time and entry-level specialty roles may not have as competitive salaries as some of their peers being entered into the lottery. So those individuals, unfortunately, would have less of a chance of selection. Generally, the student population are typically amongst some of the highest who rely on H-1B lottery sponsorship for continuation of their immigration journey in the US. So it remains to be seen sort of what the major impacts could look like with the changes being brought this year to the lottery. But what we may be seeing is that individuals need to begin exploring other avenues for sponsorship.
Well, thanks, Beulah. I really like the analogy of the raffle ticket. I feel as though I'm about to go into a British American business holiday party. Sadly, that isn't the case, but it'll be there for us in early December, no doubt. Yeah, that was a great whistle-stop tour, Beulah, of these what are really seismic developments. And I'm going to come back to you in a bit, if I may. But Aisling, maybe I could turn it over to you to talk about what other changes should we be aware of when we're considering pipeline talent.
Yeah, thank you, Stephen. So we're also expecting some changes for F1 students this year, partly because of the H-1B program changes, because so many F1 students are entered into the H-1B lottery by their employers, as Beulah mentioned, and partly because of proposed regulatory changes for F1 students that will affect their expiry dates. So firstly, with respect to the lottery system, Beulah touched on this, but one of the main issues is that F1 graduates tend to be early career professionals with entry-level wages. And this is perfectly permissible under the H-1B regulations, as long as the offered salary meets the level 1 prevailing wage. But now that lower or entry-level wages limit the chance of selection in the lottery, this is obviously going to impact F1 students, particularly in urban areas where prevailing wages tend to be higher. And the H-1B salary would only meet the level 1 wage. And then, as Beulah said, if the individual is lucky enough to be selected in the lottery, the petition needs to be filed as a change of status to avoid the $100,000 fee. Change of status petitions just tend to be really heavily scrutinized by USCIS. They're very unforgiving. They want to make sure that the beneficiary maintain their status right up to the time of filing. So again, we might see an uptick in RFEs and even denials because of this. And then there's the issue of cutting off OPT time. So in the past, it was possible to file H-1B petitions in post-lottery selection sort of as a back pocket or, you know, as consular notifications, so they could be used as at a later date when the OPT had run its course. So this sometimes could be 2 or 3 years later, and it really allowed a nice runway for folks who had just graduated, you know, in terms of work authorization. But now, because of they have to be filed as a change of status effective October 1, it's going to cut off that OPT time and, you know, reduce the overall runway. So there's also, separate to the H-1B program, there's the proposed rule to shorten the expiration dates for F1 students, which was announced in August last year. This is not a published final rule yet, okay? So it's not a final rule, but the notice and comment period has ended on the proposed rule, so it's possible we will see it published in the Federal Register this year. So we're definitely watching this closely. So under the current regulations, F1 students are admitted to the United States on their I-94 admission records as what's known as duration of status. And that means that there's no fixed end date on their I-94 record as long as they're maintaining their status. That usually means as long as they're enrolled in their degree or if they're completing their OPT. But DHS is now proposing to admit students for a fixed period of stay that would be tied to their Form I-20 end date, their program end date, for a period of no more than 4 years. So this is a really huge departure from current law and policy, because it means that students would now, in that case, need to apply to USCIS to extend their status if they need more time to complete their degree, or if they want to start their OPT or extend their OPT. So they need to file an I-539 form with those hefty USCIS filing fees. And in general, you know, it's just a lot more administrative burden, a lot more risk, tracking expiration dates, ensuring employees don't fall out of status, ensuring nobody faces a break in their work authorization. So we are definitely watching that proposed regulation very closely.
No, thanks, Aisling. I think maybe there's at least some bit of good news here. I didn't hear you say that the 2-year optional practical training period for STEM students is in jeopardy, or are we safe with that for a while?
Right. So as of now, the proposed regulations don't aim to eliminate the STEM OPT program, Stephen. But you know, some lawmakers are suggesting that it should be restricted in the future. So not right now, but we're watching it.
Okay, thank you. Well, let's move on in our pipeline talent analysis and take a look at Mexican and Canadians who might be looking to come to the United States on TN visas. With all that's going on with tariffs and all those geopolitical concerns, is the TN visa category safe for the future?
Right. Well, so the USMCA is the trade agreement between US, Mexico, and Canada. And from a talent perspective, of course, it allows certain professionals from Mexico and Canada to enter the US temporarily to work in the TN category. And the issue is that the USMCA is up for mandatory review in July of 2026. And that's where all 3 countries get to decide whether to extend the deal for another 16 years or to keep negotiating changes year to year, or even to walk away from it. So as you mentioned, there's huge political pressure in this area right now, as we all know. And given this administration's approach to trade negotiations, I think we're going to expect to see some posturing on the topic. But we don't expect there to be any immediate risk to the TN program. We don't think it's going to be eliminated outright. The focus is most likely to be on broader trade and economic changes. In fact, to change the TN program in any significant way, all three countries would need to agree on the new provisions. So even if the three countries don't come to an agreement during the 2026 review, the current USMCA agreement would actually remain in force for a further 10 years until 2036. So again, we don't expect an immediate impact to the TN program. So completely separately to the 2026 mandatory review, there is actually a provision in the USMCA that allows any party to withdraw from the agreement with 6 months written notice. But this has always been a provision in the USMCA, and it's not being reported as a likely scenario right now. Even if the US wanted to go in that direction, USMCA is enshrined in federal law under the USMCA Implementation Act, and the TN classification is also enshrined in the Immigration and Nationality Act. So amending or repealing this legislation would require congressional action. So again, not overly concerned with the TN right now.
Oh, well, thank you for that. It's definitely a sort of a watch this space kind of topic, especially as the trade talks continue to unfold. But let's continue the march through the non-immigrant visas. I know there are many BAB members who utilize both the e-treaty visa, the British-owned companies that bring Brits to the US, and of course the L1 intracompany transferee visa. Any concerns with these on the horizon, do you think?
No, I mean, the good news here is that we're on safer ground. I think with the L1 and the E visa categories, it's somewhat business as usual at the consulates abroad. There's the usual caveats. The wait times can vary across consulates. There's overall heightened scrutiny and delays that will affect all the visa applicants. So certainly L1s and E's are seeing the same. But we do continue to experience good results in London and at nearby consular posts such as Dublin. In fact, given all of the upheaval in the H and the F1 space, we would actually encourage, foreign-owned US companies to explore whether they might be eligible for the E2 treaty investor or indeed the E1 treaty trader classification. It's a really useful tool to transfer talent to the US. There's some investment required up front to register the company at the home country consulate. But for individual visa applicants, it can be a really quick and efficient tool to transfer managers and essential skills workers.
Well, thank you for that. I might add that the e-treaty visa are treaty-based, as the name suggests, based upon treaties of friendship, navigation, and commerce between the United States and a very significant number of countries. But these treaties do typically fall within the executive branch of government for continuing as opposed to the Congress. So again, we just have to hope that this administration is prepared to continue to honor these treaties and not disturb them. Let's continue the move. Violetta, let me bring you into the conversation. What other alternatives out there for employers to consider for foreign talent?
Thank you, Stephen. So I would like to highlight two additional visa categories that are perhaps not as widely utilized, but continue to provide meaningful alternatives. One is the O1 Extraordinary Ability visas, and the other one is J1 Exchange Visitor visas. Let me start with the O1 category first. So this is a category that continues to perform quite well. We are still seeing good outcomes, particularly in research-driven roles in biotech, life sciences, emerging technology. And what I'm seeing on the ground with our cases is also quite consistent with overall adjudication rates. I pulled the most recent statistics, which is from the third quarter of 2025, and the overall approval rates are 94%. So for the right profile, this remains a strong option. The key, of course, with the O1 is that accomplishments must extend beyond the employer. So USCIS will look to external validation, whether that's publications, citations, media coverage, and so forth. The point is, an O1 cannot rely solely on internal achievements. Now, strategically, I think the O1 can be a really good option for senior leaders, executives, particularly those who may not qualify for an L1 transfer because they have not met that requirement for 1 year of employment with an affiliate of the company outside of the US. Again, if we can demonstrate sustained national or international recognition, the O1 can be a viable path. And then a second category I want to highlight is the J1 exchange visitor visa. There was a major development for this category in 2025. Actually, it was at the tail end of 2024. So there was historically this 2-year home residency requirement following completion of a J1 program in the US. And this was removed at the end of 2024 for some 37 countries. And historically, this was one of the major drawbacks of utilizing the visa. So it was a really, really positive development. I should note that the 2-year home residency requirement does still apply in some narrower circumstances, particularly when there's government funding, whether through the US government or the foreign government. There are waivers available and they can be relatively complex depending on the circumstances, but those are much narrower circumstances. So the skills list is primarily gone. Now, the J1 is much broader than many employers realize, and it includes 14 distinct program categories. For our purposes here, I'm just going to highlight 3 of those that I think can be particularly useful for those early career pipelines. The J1 intern category, that is for students or recent graduates from a program abroad. And it provides work authorization for up to 12 months in the US. We also have the J1 trainee category. This is for individuals who have a degree abroad and at least 1 year of experience, or if there is no degree, then the individual must show 5 years of experience abroad. So this particular category can authorize up to 18 months of work authorization and stay in the US. And then beyond interns and trainees, there is the J1 research scholar category, which can authorize up to 5 years of stay in the US. Now, while the J1 research category is commonly utilized for advanced degree holders, the requirement really is as little as a bachelor's degree. Of course, research can extend into the private industry as long as there is a genuine research component and sponsorship has to be structured properly. But I think this is something that has been overlooked and may be available for certain profiles. Now, I just want to mention that the regulation that Aisling was mentioning regarding the elimination of duration of status and replacing that with a fixed period of stay, that would also apply if adopted to the J1 category. So instead of 5 years for the J1 research scholars, it was shortened the runway to 4 years. So the takeaway here, these are less utilized, but for the right profile, both of these visas can be really viable options.
No, well, thank you for that. I think you said 94% approval rating for O's. There are a lot of extraordinary people out there, quite clearly. So that's good. And yes, the J is this, has these many hidden areas of it. It's a terrific program for employers to consider if they've got the right profile again. I think that should really cover it for pipeline talent with respect to non-immigrant visas, but what's it looking like for the long term? What's the runway for that like? Are we seeing changes in the green card pathways, Violetta?
Yes and no. So we're not seeing changes in the green card categories, right? Those are set by statute and they require congressional action to change, and we haven't seen that. The one exception here, of course, is the Gold Card program. So this was a program that was introduced by executive action in September 2025. So what this program seeks to do is to allow individuals to make a $1 million unrestricted gift, or if filed through a corporation, a $2 million unrestricted gift. And it seeks to fit those individuals within existing employment-based preference categories, namely the EB1 and the EB2. We already have litigation on this program. There was a lawsuit filed earlier this month by the American Association of University Professors. And of course, the central question that the lawsuit poses is, does the president have this authority to rewrite essentially eligibility for the green card categories? So this is something that we also are going to be watching closely in the coming months. So no statutory changes, but where we are seeing a lot of change is in the area of adjudications. And the environment has simply become much more restrictive in practice. We are seeing increased scrutiny and audits for perm labor certification cases that require testing the labor market. And here the stated policy goal of the government is, again, to protect jobs for American workers. And amidst significant layoffs in the technology sector, we are seeing a lot of focus on the perm program. We're also seeing a lot more challenges for categories that bypass the labor market testing. So extraordinary ability petitions, not O1, but in the green card context, EB1 extraordinary ability petitions, we're seeing more scrutiny, and also EB2 national interest waiver cases. The approval rates for these have really dropped precipitously over the past year. One outlier is the EB1 outstanding researchers category. That category continues to perform really, really well, but it is much narrower. It is for publication-driven research profiles. One development that I want to mention here is that there was a recent federal court decision that essentially challenged the government's two-step framework for adjudicating extraordinary ability cases. And this two-step review is really where we're seeing a lot of scrutiny. So what is the two-step framework? Step one, an officer looks at whether an individual meets 3 or more of the regulatory criteria as is required. And then the second step is what we call a final merits determination that essentially requires the officer to look at the evidence in its totality and make a discretionary determination whether the evidence is strong enough to show that the individual is at the top of the field. So what the court really had a problem with was this second step. It indicated it is really a substantive requirement. It's not in the regulations. So this is a really positive development. And I think, we are putting this case as persuasive authority in these types of cases. But I do want to caution, it's likely going to be short-lived. So what we have on the government's regulatory agenda is immigrant visa reform. We don't have the text of what this regulation is going to include, but we are expecting that the government is, in fact, going to codify this two-step framework and also otherwise narrow eligibility for some of these green card pathways. So we'll have to stay tuned for that as well. Bottom line, no statutory change, lots of change with respect to adjudications, and we may see new regulations narrowing down eligibility.
Thank you for that, Violetta. A lot of these immigrant petitions for people of extraordinary ability did get tripped up, not because people didn't meet the threshold criteria, but they get tripped up on that final merits question. And so it's good that that has been set aside, at least for the time being. And we have a reprieve on that. I'm going to switch our focus now and go into a second part, which is relating to compliance considerations. And really, when we look at compliance, of course, it's not only employer compliance, but it's compliance by the individual, by the foreign national, as an individual who's walking the streets of their homes. Violetta, maybe you can comment on what we're seeing from an employer perspective, things that employers really need to be focused on right now in this environment.
Sure. So 2025 has been quite active in enforcement, and I really want to single out one area here, and that is wage compliance. So the administration's stated goal is protecting American workers, protecting American wages, and wage compliance is really front and center. We're going to be seeing more scrutiny, not only at the time of filing, but also post-filing through investigations and site visits. In September 2025, the Department of Labor launched an initiative. This is an H-1B enforcement initiative called Project Firewall. And it is an initiative that is being coordinated with other federal agencies. So traditionally, these investigations were complaint-driven. Now, under Project Firewall, the Department of Labor is personally certifying investigations upon reasonable cause. So quite a change there in terms of focus and intensity. In tandem with this, we're also seeing increased FDNS site visits. So what FDNS is, it stands for Fraud Detection and National Security Directorate. It is an investigative arm within USCIS. And essentially, officers show up at the work site, whether that's the company work site or for remote or hybrid workers, that can be at the home residence where work is performed. And the aim is to verify the terms and conditions of employment, including the job duties, the location, and also the wage levels. Material discrepancies can result not only in petition revocation, but in certain circumstances in additional penalties. Now, as Beulah mentioned earlier, we have that new regulation on weighted selection. With that regulation, the government is also releasing new H-1B forms. We are expecting that may in fact happen on February 27th, which is the effective date of the regulation. We're expecting that potentially it may happen without a grace period, as was the case 2 years ago when the form was updated. And the new forms are going to require much more detailed information for data that pertains to wage leveling. So all of this is really pointing to increased scrutiny on wage leveling. How are employers leveling positions with respect to Department of Labor prevailing wages? And I want to highlight one additional development here that's really imminent, and it's almost hot off the presses, or maybe not quite, but there's going to be rather a proposed regulation that seeks to modify how prevailing wages by the Department of Labor are essentially set or determined. So this regulation has not yet been published, but it just cleared review by the Office of Management and Budget on February 20th, so several days ago, and we're likely to see the text in the Federal Register in the coming days and weeks. Again, we have not seen the text, but the expectation is that it will likely increase prevailing wages and wage requirements for the H-1B program. So I think for me, really the focus for this year, where I think there's going to be a lot of action, is on wage attestations, wage compliance.
Well, thank you very much, and for that hot off the press development. A lot to come here for employers to be thinking about in wage leveling. Beulah, let me come back to you. For individuals, what do they need to be really careful about from a compliance perspective?
Sure. Yep. So this heightened focus on compliance is definitely felt on the individual level as well. A few things to sort of make note of and trends that we're seeing. First, it's now more than ever really vitally important that individuals are carrying and maintaining up-to-date status documents and records, and specifically keeping a watchful eye on their I-94 records after travel. So anybody that's admitted in a non-immigrant status should be checking their I-94 to ensure that they were admitted in the correct status and that they were admitted through the correct and full validity period of stay that corresponds to their approved petition. Another thing that we're seeing is a slight increase of requests for in-person biometrics appointments. The administration has phrased this as an effort towards heightened security vetting and fraud prevention. So we're seeing an uptick in requests for individuals being asked to attend these in-person appointments for photographs and fingerprinting in order to have their applications and benefits adjudicated. So these are coming in through the form of a request for evidence, which pauses processing on the application until the appointments have been completed, and then evidence of attendance to that appointment has been submitted back to USCIS for them to resume processing of the application and benefit. And then the last thing I'd mention is just the concept of continuous vetting. So essentially, this means that enhanced security checks are not only present at and relevant at the time that you initially apply for a visa, but they continue to be relevant throughout the immigration journey. So any derogatory information that resurfaces could cause re-adjudication at any time. Last year, we had instances where we saw consulates issuing prudential visa revocations for people in events where they had already been issued visas in the past, but the consulate acquired some sort of evidence of historical infraction of laws or issues that caused them to dig deeper and re-adjudicate and reevaluate applicants' eligibility for visas that have already been issued. So this, of course, has a massive impact on individuals and global mobility in general and bringing foreign talent into the US.
Yeah, thank you for that. One area that is always so upsetting is when someone looks at their Form I-94 and they realize that it's already expired. And I think employers really need to be hammering home to their employees, please check your Forms I-94 after arrival. People who've just flown in from halfway across the world, of course, aren't rushing to get their Forms I-94, but they need to do so because both CBP, Customs and Border Protection, and USCIS can be quite unforgiving when it comes to correcting an expired Form I-94. With that, let's now turn to the final section and look at the impact of the administration's policies on mobility. We were, of course, in the first Trump administration from 2017 to 2021, we got used to the travel bans, and certainly we were sort of expecting that those would resurface in some formal shape. And indeed, they have. And as we look at people outside the United States trying to get into the United States with travel and mobility concerns, maybe Violetta, I can put it back to you. What are you seeing for people who are applying for visas? What are you seeing at ports of entry? What's all the news there?
Sure. So there really hasn't been a dull moment, right? We have had so many changes at the consular level. And I think the tone for this was really set at the beginning of last year when the administration took office. Essentially, the framework is, or the lens is, that every visa decision is a national security decision. I think that was a quote by the Secretary of State. So what are some of the main initiatives we've seen here? First, the Department of State eliminated interview waivers when individuals are applying for a visa. This provided a lot of flexibility right after COVID. It is now essentially mostly gone with very, very few exceptions. We also saw the elimination of third country national processing. So individuals now must apply either in their country of citizenship or their country of residence. Cannot go to another country where you happen to be on business or for another reason. And then we also saw initiative for mandatory social media vetting. This was rolled out first for F1 and J1 applicants earlier in the year. And then at the end of the year in December, it was also rolled out for H1B and H4 visa applicants. So applicants in these categories are required to set their social media to public during the consular visa application and the interview. So what this has done is, of course, it has created a lot of backlogs. In some consulates, it has also increased administrative processing post-interview. And of course, these developments together have really put a lot of pressure on high volume posts such as India. So in India, what happened was that individuals' appointments were rescheduled multiple months out, and they continue to be limited. Appointments are now well into 2027. So because of these developments working together, I don't think there is a pressure valve that can be essentially turned on and off. An individual cannot go to a different consulate. So I think we're going to continue to be seeing these challenges well into the future. And I think this is an area where employers and employees really have to plan ahead.
No, thank you for that. And what about travel bans? There's been a lot of activity there, Aisling. Good luck getting us through all of this.
Yeah. No, look, I'm going to attempt to parse out the various travel bans and the immigration pause that's at USCIS right now. I know we only have a few minutes left, so I'll try to condense it. Look, it's part of a patchwork of presidential proclamations, agency memoranda, and policy that, they have different country lists, different legal basis, and different outcomes for individuals depending on their particular circumstances. So it can be quite difficult to track, and it does require some legal analysis. And I would just say, despite the purported legal rationale for the travel bans, they seemed to be more designed to deliver a political message rather than being any part of any coherent strategy to address national security or public policy concerns. They've really sown a lot of chaos and fear. And from a global mobility perspective, it's really extremely difficult to support talent from these countries at the moment. But let's start with the travel bans. In June 25, as part of the broader national security effort, President Trump signed a proclamation suspending entry into the US for all visa types for nationals of 12 so-called high-risk countries. And he also partially banned visas for an additional 7 countries. So the countries were primarily in Africa, the Middle East, and Haiti. And there were clearly articulated exceptions to this ban, including for those who already held valid visas, for those with US green cards, dual nationals of countries not subject to the travel ban. So, for example, a UK citizen who was also a citizen of Iran. And there were another number of other exceptions, including for diplomats, athletes, etc. And there was a carve out if the visa would be in the national interest of the US. But that can be a very difficult burden to overcome. So this travel ban was expanded in December 2025 to add additional countries. fully or partially, and it brought the total number of banned countries to 39. Again, the focus was primarily on countries in Africa and the Middle East, as well as, for example, Venezuela and but people with travel documents from the Palestinian Authority. And the same exceptions to the initial travel ban generally applied. And then USCIS got involved in December of 25 as part of the same national security push. USCIS issued an internal policy to its officers directing an adjudicative pause on immigration applications filed for the nationals of the 39 countries. And they told officers to hold final decisions on these cases while conducting enhanced screening. Due to the wording of this policy, initially there was a lot of confusion about which applications it applied to, but we believe now that the pause applies to all immigration applications for those folks from those 39 countries, including, for example, H-1Bs, L-1s, I-140s, adjustments. And we understand that new applications can be filed for those people, but final adjudication will be held pending further review. There's really little guidance from USCIS on what criteria will be used for the review, and whether cases will in fact be adjudicated once this screening is completed to their satisfaction. It's quite a new development, so cases haven't really gone through the full life cycle of processing yet to see how it's going to really play out. A huge part of this is that the exceptions to the travel ban don't apply to the USCIS pause. So you could have a situation where a dual citizen, for example, of the UK and Iran, that is not subject to the travel ban, will be subject to this USCIS pause because it's cast a much, much wider net. Another concerning part of the pause is that they have mentioned that they are going to possibly re-review cases that are already decided and closed, or people on the travel ban list who have entered the US after January 2021. So unfortunately, we are already hearing some anecdotal reports of USCIS issuing RFEs for cases that have been decided a long time ago, and even notices of intent to revoke. So it's really, really concerning. And then just finally, I just wanted to add that in January 21st, 2026, the Department of State then issued another policy adding additional countries to the travel ban list to bring it to 75 countries, but this time it was only with respect to immigrant visa processing, and that's green card applications at the US consulates abroad. And this doesn't really come up very often in the employment-based context because most green card applications in that space are filed as in the US as an adjustment of status, for example, from an H or an L. But in any event, the 75 country list overlaps with the main travel ban list, and it adds additional countries, including, for example, nationals of Brazil, Colombia, Pakistan, and it's purportedly related to the concern that applicants from these countries could become a public charge on the US when they immigrate. Again, there's no guidance on how long this pause will last, what criteria will be applied, etc. So from a global mobility perspective, as others have mentioned, these pauses and bans are highly disruptive. There's no clear parameters, and it does increase the need for workforce planning and compliance.
Gosh, thank you for that. We have a few minutes left. I've got a few questions here, and maybe I can put them to the panel. There are a couple that relate to, in fact, business travel. The first one actually is not about travel to the United States, but travel to the UK. Beulah, maybe I can ask you to talk a little bit about that.
Yes, I've just been researching this actually, hot off the press. So coming into effect tomorrow, I think this is what you're referring to, Stephen. Coming into effect tomorrow, all non-UK and Irish citizens that are traveling into the UK, this includes Americans, must complete and present Form ETA and pay the accompanying fee in order to be admitted into the UK before travels. So for anyone like myself, any dual US-UK citizens on the call, this means you have to use your British passport now when entering the UK moving forward. Stephen, I think that BAB recently issued a memo on this, which is probably quite informative and has some good information about this as well.
Yeah, it's a great memo giving people exact instructions. So for the dual citizens, Brit Americans who are in this program, you've got to blow the dust off your British passport, basically, if you're looking to go to the UK. You will not be able to get into the UK on your American passport with an ETA. It won't happen. The other piece of this was actually travel into the United States on a B1 visa or indeed an ESTA. What has the administration been doing for business travelers? Violetta, maybe anything come to mind there?
For business travelers, we are seeing some scrutiny at ports of entry. And essentially, I think it has to do with the scope of what is permissible under the B1 visitor visa and ESTA. So, what level of activity rises to, productive work such that a work permit would be required. I think this definitely warrants strong business travel governance from employers. Another area is with respect to, the question whether the activities are for the benefit of a U.S. entity. So where we're seeing this is with multinationals, right, where we have leaders or executives that may, lead in part US-based teams, are those activities properly within ESTA? I think there is some thought that needs to go into that, and a risk assessment and proper structuring. And then, I think this came to the fore last year. There was that widely publicized raid on the battery plant in Georgia, where we saw hundreds of South Korean nationals, right, being arrested, and it turned out that they had come in fact, as business visitors. There is a particular provision there for, after sales servicing. So essentially, technicians can come into the US to service equipment or to install equipment or to train US workers, provided there is a contractual provision. But nonetheless, right, we saw that action there. So I think these are the main risk areas for business travel.
Yeah, no, thank you for that. Amrita, I'm conscious of time. Sadly, we've covered a lot of ground, but I think we are on the hour, and I think I need to turn it back to you.
Yes, wonderful. Thank you so much. A big thank you to Stephen, Beulah, Violetta, and Ashlyn for a highly insightful and informative discussion today. Thank you again to Gibney. And on behalf of British American Business, I'd also like to thank you all for joining us today. We look forward to continuing the conversation with you at a future BAB event. Have a wonderful rest of the day.
Thank you very much.
Thank you.
Thank you.
Thank
And
you.
if anyone, I'm sorry we couldn't get to more questions, but by all means, get them to us. We'd be pleased to respond to you, and have a very good day. Thank you for joining us.